Hello, everyone, and welcome again to another episode of Letter of Law. My name is Sarthak, and today I am absolutely thrilled to be in conversation with an extremely special guest. We have Mr. Aditya Vikram Bhat with us. He graduated from NLS back in 2003 and has thereafter worked in some of the best law firms of the country. He worked in Dua Associates and at AZB, where Aditya was a senior partner. And Aditya has very recently set up his own chambers, which is the Chambers of Aditya Vikram Bhat, and he's based out of Bangalore, which is where he's joining us from at the present moment. So, Aditya, to start this off, first of all, thank you so much for taking out the time and speaking with me. I'm so glad that we could make this happen today.
Not at all, Sarthak. The pleasure and privilege is all mine. Thank you for having me.
So, Aditya, to start this off, when we were trying to organize this conversation, you suggested that I should not address you as sir and rather use your first name. And
Right.
now, as a junior lawyer, Aditya, I always find it odd because I do get these requests from my other guests as well. But it's always a little strange to address someone so senior to me in the profession by their first name and not sir. So I'm just curious to know, Aditya, what's your thinking about all of this?
Yeah. So first, of course, Sarthak, this is the tradition of the bar. If you look at, if you read literature or fiction that comes from the bar, be it the English bar, from where our professional tradition sort of evolves. We the trend has always been to use first names regardless of seniority. It is not a mark of disrespect at all. So that's point number one. Point number two is that the thinking behind it is that we are professional equals. The your law degree, once it is conferred, is as good as mine. Your gown is as good as mine, and therefore, and before a court of law, we are equal. And therefore, amongst similarly qualified professionals, the best thing to do is treat each other with respect and treat each other equally. Um, the third, I mean, all of this is in theory. The third factor, of course, is that at AZB, where I was for 20 years, we used first names for everybody, including, our founding partners. And I thought that was like a great practice. You see this reflected when you're traveling abroad. There are no sirs and ma'ams and uncles and aunties and all of that. You call each other by their first name. Uh, some sort of uh, geographies still insist on traditions. For example, if you're traveling to Japan, the practice is slightly different. Other places in East Asia or Southeast Asia, the practice is slightly different. But you can sort of fine tune the approach for those geographies. But by and large, I think amongst professionals, we are in a first name environment today, and there is no need to. Let me put it the other way. There is a need for young lawyers to graduate from law school. When they join the profession, they are professional equals.
Wow. That's an incredible perspective. So, because in law school, the idea is drilled into our heads that you first of all have to address your seniors as sir and ma'am. And the idea is because when you enter the profession, that's the nomenclature that's going to be used.
See, I don't know where that comes from, and I don't know if it comes from any professor who's actually practiced. So that's one. The other thing is, you know, when you're walking down a corridor, let's say, you're in a strange court, you're appearing in a court for the first time and you don't know where your court hall is or where the bar room is, etc. And you see a gentleman lawyer or a lady lawyer walking past and you want directions. Sure. I mean, depending on sort of, what the color of your hair is or whether you have hair or not, you can choose to use brother, sister, or sir, because it's a sort of mark of respect and courtesy at that moment in time. But once you've sort of shaken hands, introduced yourself, and possibly exchanged cards, it's uh, it's not uh, uh, it's not required. So there are uses. I can't imagine, going to a court for the first time, having to appear, uh, you know, uh, let's say in Jabalpur or Chhattisgarh for the first time, and uh, wanting directions to the court hall, and I can't think of anything else to say.
Hmm.
Sir, brother, maybe, or sister, maybe correct usage. But I think after that, it is first names.
Right. And to start this off, Aditya, when I gave an introduction of you, that's the professional understanding I have of you based on your LinkedIn profile and other information available on the internet. But I'm curious to know, how would you like to introduce yourself to our listeners? And is there anything else that you think our listeners should know about you before we dive right into the conversation?
So, in my mind, I consider myself a trial lawyer. I consider myself that most comfortable in the trenches of trial courts. I have the ability to take my own motions up in appeal all the way up to the Supreme Court. I have the ability to take my own final judgments up in appeal all the way up to the Supreme Court. Depending on which side of the winning or losing sort of toss of coin I am. And so therefore, arising from my trial practice, I've been fortunate enough to appear uh, across the country at courts from the lowest to the very highest. But I still consider myself at home in a trial environment. Equally, in the arbitration spectrum, uh, I sort of relish the opportunity to do the fact-finding exercise, the trial exercise before a tribunal, and I bring my experience from the court to bear on that process. That's not to say I've not had a writ practice or I've not had uh, uh, motions practice at the High Court or the Supreme Court. Uh, the profession has been kind and I've had those opportunities, but I'm talking about where I'm most at home. In terms of practice areas, given the firms that I was at, and especially the 20 years at AZB, a lot of my clientele is from the corporate universe. I do have individual client or family office clients, but fewer than my corporate clients. Um, Therefore, for the corporate clients, the disputes are quote unquote corporate in nature. It could be shareholder disputes, it could be corporate control disputes, it could be commercial disputes relating to companies, it could be white collar defense arising out of corporate transactions or commercial transactions that the companies have undertaken. So that's the broad profile. What else? I mean, it's outside of the law. I'm a farmer. Uh,
Oh,
Outside of the law, I have a little art collection. Outside of the law, uh, I don't know. I'm a sort of traditionally religious and spiritual person. So uh, that's I enjoy spending time with my family.
wow.
So that's as much as I can.
Yeah.
I used to play cricket. I used to be a martial artist, but that's almost another lifetime back now.
Thanks for sharing all that, and I'll try to circle it back to those things. But to start it off, I'm really interested how you described yourself as a trial lawyer who's most comfortable fighting it out in the trenches.
Sure.
And so, Aditya, the misconception that I have in my mind is that corporate lawyers who work in tier one top law firms don't essentially have, a lot of court-facing work to do. And when one thinks of an image of a trial lawyer who's fighting it in the trenches, one thinks of a district court lawyer who's probably running around, sweating it out. So please, I would like you to dispel these misconceptions that I have and enlighten me on
Yeah.
how even those who work at tier one law firms have trial experience and fight it out in the trenches, as you put it.
Yeah. I think there are two or three factors at play over here. The first is, of course, the Bangalore story, right? Which is that the Karnataka High Court in Bangalore does not have
Hmm.
original civil jurisdiction,
Yeah.
right? So therefore, let's say you have a suit, uh, the relief of which is valued at 10,000 crores. It needs to go to the city civil court in Bangalore. Yeah. And outside of the jurisdiction of the city civil court, it needs to go to a civil court senior division with the exceptions, the statutory exceptions that go to the district court. It needs to go to the civil court senior division in other districts. So that's the first thing you need to understand. Coupled with that is the Bangalore growth story. Since I graduated and joined the profession in 2003, industry, commerce, opportunities in Bangalore, specifically, and Karnataka more broadly, have skyrocketed, right? And so therefore, when you have a dispute, where do you take it? You take it to you take it to the court of first instance, which is the civil court in Bangalore. And that's a court that is a stickler for the CPC. That's a court that has some of the best district judge cadre judges in the country, and now suddenly for the last 20-25 years, it also has the best some of the best work in the country. I mean, not to take away anything from the other courts, it has some of the best work in the country, and so we need to file our written statements in time. We need to make all our motions for discovery, inspection, all of that in time. We need to file our list of witnesses in time. We need to file our objections to motions filed by the other side on time. There is the practice of appearing in the first call, having the matter passed over or kept by, as we call it, and appearing again in the afternoon. Witnesses have to be present at every date of hearing. If you haven't produced a particular document, you need to file an application explaining its relevance and your inability to have furnished it at the relevant point in time, instead of just handing it across the bar and saying, my lords, a few documents for you to look at. So that mindset that, look, I have forgotten something, or the younger lawyer that's working with me has forgotten something, but you know what? Hey, I'm going to hand it across and say, please look at that. It's never on the record earlier. So that's the training, right? So this is one aspect. The next is because we're there, and unlike some of the charter courts in the country where initially trial was not happening at all because the Delhi High Court a court is a court with original jurisdiction. That is somewhat of an exception, even historically. But the other high courts with original jurisdiction, there was no trial happening at all for a very long time, and therefore the life cycle of a suit was 15 years, 20 years, right? So once you've sort of finished your motions, taken your injunction application all the way to the Supreme Court, you are sort of waiting for it to come back to life again, or maybe your children, if you have children in the practice, can take it over from you. But in Bangalore, the life cycle of a suit was always 3 to 5 years, right? Oh. So after a year and a half, the court has framed issues and you have to put your witness in the box. So once you put your witness in the box, if you're the plaintiff, the defendant cross-examines. If you're the defendant, the plaintiff's witness is in the box and you have to cross-examine, right? So a suit that I filed in 2003, in 2004, I'm ready for cross-examination. And there's no option, right? So you can either do a good job of it or you can do a poor job of it, right? So that's the second part, that a life cycle of a suit from filing to final judgment. If it is 3 years, then you are going to have to conduct trial. There's no option. It's the disparity has reduced a little bit now, but if you looked at how many interlocutory motions or interlocutory appeals or revision petitions or civil writ petitions were going from Bangalore to the Karnataka High Court, and how many of them were coming from districts outside of Bangalore urban, the disparity was quite stark, because the distance from the City Civil Court Bangalore to the Karnataka High Court is hardly a kilometer, right? And if you're thinking in the late 90s, I mean, going back any point in time, or late 90s or early 2000s, from somewhere, say 300, 400, 500 kilometers away, if somebody thinks that, look, they've suffered a wrong order on an interlocutory application, their ability to cost-wise, effort-wise, time-wise, to find a lawyer in the Karnataka High Court on an interlocutory motion, which is a 50-50 case, appoint the lawyer, have the suit stayed, argue this, take it back. There was a mental barrier, if not a real barrier. So my experience was, or my observation was, that people that we called Mofussil lawyers were actually far more meticulous when it came to conducting, trial work. Far more meticulous when they were doing their work in the court of first instance. Pleadings were a lot more detailed. It was a lot more carefully done. So some of that learning, that look, this is the specificity with which pleadings are done. This is the specificity with which research is done. This is how matters are argued. Some of that learning impacted me.
Yeah.
The next factor, of course, is the individuals that I had the opportunity to learn from. My first bosses and mentors, KG Raghavan and Arun Kumar, both of whom designated senior advocates, that spent a lot of time, effort, energy, entrusting work to me and then mentoring me. Mr. Uday Holla, who I never sort of worked in his office, but have briefed him just so many times when I was younger, that he's a person that I always look to for advice and mentorship, etc. Just their teaching, and Zia, of course. Zia's sort of profile today is that of a M&A lawyer and a M&A super heavyweight, but her heart and her roots are in litigation. And it's just incredible when she sort of puts on her litigation hat again. The specificity, the knowledge all comes rushing back, that experience all comes rushing back, the DNA comes rushing back, and the amount that a young lawyer can learn from her. So these four individuals, amongst others, I mean, you learn from everybody in the profession, but these four individuals and their attention to detail and their and their ability and their willingness to put up a fight has had a very big impact. So these are 4 or 5 things that have sort of shaped it. In addition, in corporate firms, if you have the capability, and in Bangalore, we never had the solicitor counsel sort of split. Why would a client want you to go and engage somebody else when he's getting the best of both worlds within the office, right? So why would you add a layer of course, there are matters that deserve it. That there are matters that deserve the additional thought process, the additional sort of ideation, the additional value add. But before you get there, why is the client going to come in and say, you know what, let's in any case have another layer of lawyer when I have somebody that is able to provide me full service? No, but I'm just going to add another layer. So less likely to happen in Bangalore. Then, I mentioned that all of my clients historically and even today have been large corporates. Large corporates come with their in-house teams. Now, their in-house teams, of course, are of course lawyers. So who you are advising is actually another lawyer. Okay, so you are a lawyer's lawyer, right? And you are advising them in the context of a court of first instance, right? So you have to have that value add, that sort of that earthiness, that familiarity with the court environment that they cannot get from their office environment, right? So if you are also going to talk, what in Hindi we say upar se, then he can do the same thing, right?
Yes.
So where is he getting the trench, or where is she getting the trench knowledge from, the intelligence on the trench from? They're looking at you to provide it, So, and why wouldn't you provide it? You're getting paid for it. You have the opportunity to learn and then pass it on, right? So, I'm not saying that your impression about litigation practices in large corporate firms is misplaced. I'm not saying that my experience is common, uh, but I've been fortunate for the number of reasons that I've mentioned to be able to have the best of both worlds. Have a support structure of a very large, a behemoth of a firm around me, and be in the trenches while enjoying that support. So slightly long-winded answer, but I hope that it sort of uh, answered what you were looking for.
Absolutely, it does. And I'd like to move further from this now. And I'd like to talk a bit about when you went independent at a later stage during the conversation. But right now, I'm curious to learn, how does career progression occur in a law firm as compared to litigation? For instance, one often hears that if you have a godfather or a godmother in the profession, it's easier for you to litigate. But the picture one paints about law firms is that they are more meritocratic places. You know, you work hard in law school, you either get placed, or through a PPO, you secure a job. Then, if you keep working hard, you can eventually rise. Is that true about law firms, that they are far more meritocratic as compared to litigation? And if you keep working hard, you can eventually rise up to the top. Whereas in litigation, it's a bit more based around luck and other factors that surround one.
Karthik, I mean, your question asks broadly about law firms. I can only answer about the law firms that I have been in.
Yes.
And therefore, uh, in the context of AZB, yes, completely meritocratic environment. Uh, as human beings, everybody has their likes and dislikes, and therefore, somebody's style of working may gel more with a particular partner, a particular senior partner. um, and there is an element of luck involved, right place at the right time. Where were you when that huge life-changing matter came in? It came in at 11 p.m. one night, and you had to get on a call with somebody in New York or San Francisco, and well, you were the associate available. So there is an element of luck involved, right? Because that was the sort of life-changing matter that changed the opportunities, your learning, your ability to deliver, your billing, everything.
Hmm.
But with these two or three sort of exceptions, somebody likes your style of working better, or you were there at the right place at right time. With these sort of elements of luck accepted, yes, a firm like AZB is a highly meritocratic environment. Um a lot of people there in the rungs of senior partnership are first generation lawyers. A lot of them are from diverse environments. A lot of them are lateral. A lot of them are homegrown. So there is no you can't put a formula that you can only make it to the top rung if you're homegrown, or otherwise no, you'll never get to the top rung if you're homegrown. You need to be a lateral. There's no
Hmm.
there's no formula. There are both, right? Uh, and that depends on. So the idea is this, as I understand it, that look, there is an anchor, right? So there is a set of founding partners who come together, found a practice, stake their capital in the practice, create the letterhead, the reputation of the letterhead, put their capital into the practice, and in that sense, put their capital at risk. Uh, and the mindset has to be one of growth and acceptance. So if you are willing to grow, work tirelessly, accept work, deliver quality consistently, and grow, then the platform itself becomes wider, right? The opportunities become wider. The people who came in as zero-year associates start growing, and then you have to say, look, now I'm willing to sort of satisfy their ambitions, because the platform allows it.
Hmm.
The size of the firm allows us to acquire more real estate, and we are going to do it. The size of the firm allows us to create more equity, and we're going to do it. The workflow is there, and then you share the onus of generating work with the person that's coming in, so on and so forth. The letterhead brings in some, the senior partner brings in some, and the newly minted partner brings in some, and that proportion can keep changing, right?
Yeah.
So if you have that mindset, sure, the meritocracy works. But traditionally at the bar, the mindset was that, look, I am the service or the commodity that the client is coming from. I can be hardworking. I can be sort of selective about my matters. And in my journey, there will be people who will help me, and I will help them by introducing them to clients, etc., etc., giving them opportunities, face time before courts. But there is no mindset that, look, today I'm doing, I don't know, uh, under my brand or under my umbrella, I'm doing uh, 15 matters a day, 20 matters a day. And tomorrow, if I have somebody who is not me, but carries my professional DNA, and carries my mindset and carries my brand, this brand can do 50 matters a day, right? Because it's scaling. Uh, and that's the difference. The amount of time you have to, in a law firm environment, spend to train, nurture, create infrastructure for younger lawyers, give them a seat at the table, think of them as substitutes for you in the right matters, right? I know, look, you came to my chamber to engage me, but I think my colleague, my younger colleague, is able to do this matter just as well in this context before this court, on this subject matter, whatever it is. And therefore, please take her to court, or please take him to court. And that frees up my time to do another matter, right?
Yeah.
Not to send them to take time.
Hmm.
Mr. So-and-so is on his legs in another court, maybe have it at 4 p.m. or maybe tomorrow, etc. That's another thing altogether. Not to prepare, not to rehash the list of dates, but go and do the matter effectively, right? That's freed you up for another matter. That's given you a sense of what risk you can take with that younger lawyer. Because if she does well in one matter, you will repeat that experiment again and again and again until it is no longer an experiment. And sure, you don't want to call it a partnership because you're not you're in a council chamber, you're not in a firm, you don't want to now introduce a partner, and therefore it becomes a partnership and firm, etc., etc. And then you're competing with the briefing firms or the solicitors firms. I get all of that. But have you invested the time in training that resource so that they rise to a level where they are substitutes for you in some context? And if you've done that, then you're again in the meritocracy game. Otherwise, you come to a level where you said that, listen, I've just done so much in the profession. Uh, and I have juniors, all of whom worked with me for 5 years, some for 4 years, some for 3 years, and they've sort of set up their own practices. Some of them are now designated, some of them are judges, some of them are doing really well. I mean, all of them are doing really well. But hey, I have this thriving practice, and it is now time for me to retire and play golf. So who do I hand this over to? You know what? I have a son, or I have a nephew, or I have my best friend's son who's been working with me. I think it's safe to hand it over to them and go, right? Uh, I think I sometimes I think that is sort of uh, the sort of the trust in handing over the practice to the family. It comes as a default option because you've not spent time creating a replacement, right? And because it's never been on your mind that you need a replacement. Well, you don't need a replacement because the profession will be kind to you, and when you retire, you can sort of mop all of it up, put it in a nice kitty and play golf. That's great. But When it matters is your growth phase, where you're doing 20 matters a day, stretching yourself to do 20 matters a day. You cannot stretch yourself to do 50 matters a day unless you have a second rung. So that is where the mentality in a firm is different. And another person who's going to share those matters with you requires the infrastructure. Why are you going to put them, 6 of them on a dining table around a table with one light and, one plug point and one washroom for everybody? Create the infrastructure. I think that's where firms, and especially a firm like AZB, differs, that the story is growth.
Yeah.
The story is growth. Whereas for individual practitioners, the story is excellence, no doubt, but not scaling.
Yes.
Then, of course, there's the other side of the coin, which says, with scaling comes dilution, and then why should I share my name and letterhead? Of course, all valid points. And, this is a traditional model, it's worked best. But since you asked the question, and I happen to have seen both worlds, this is my view on it.
Incredibly profound insights, and thanks for that. Moving on, sir, because you have over two
Aditya.
decades, Aditya, right? Because you have over 2 decades of experience in AZB, and you are, I'm certain, aware of the culture in other firms. I'm curious to get your perspective on this. Whenever I sit down and have a chat with my friends who are working in law firms, the idea is that somehow, somewhere, these places are toxic. That's the word that comes around. And I wonder why that is. Because, sure, the hours are interminably long, but so is the remuneration and the other factors all. Put together, this is a choice that people took by themselves. So, why do you think that law firms are often called as toxic places? Are they toxic at all? And if yes, what can be done to remedy that?
Look, there are 3 or 4 factors over here. One is, uh, have you understood what you're getting into, right? Uh, let's say, Sarthak, you want to join the army, right? A very large proportion of our forces are deployed in inhospitable terrains, right? There are patrols that don't get fresh food for weeks at end, right? Even within that, like I'm talking, there's, let's say there is a battalion that's deployed in the mountains of Kashmir. There may be a platoon or a section from that battalion that goes out and patrol for 3 weeks, carrying whatever they can on their backs, right? So be it fresh water, be it food, be it medicine, be it ammunition, etc. And let's say within that patrol there is an ambush, or there is some sort of an encounter. The conditions are inhuman, unhospitable. You do not have toilets. Sometimes you cannot move. When you're seeing the enemy or a terrorist infiltration, you cannot move. You're lying on the grass in the dew, and it's in the winter, it's sort of chilling you to the bones, but you cannot move. So why is there no mutiny? Everybody has a weapon. Why is he not? And and then you have a young officer who's maybe 5 years, 10 years younger than you, but is barking orders. Ye karo, wo karo, jaldi chalo, ye karo, whatever. Why is there no mutiny? Why is, God forbid, but why is there no mutiny? The training, right? The training tells you that, look, this is what you're getting into. The country is behind you. And if you go to sleep, or you are more worried about, saaf pani hai ki nahi, and whether you can go to your, whether you want a clean washroom or not, or whether you want garam dal roti and in naram roti, garam dal, etc. The country is behind you. You let somebody into the country, and now they're not going to be traceable. See, once somebody reaches, Jammu city bus stand, everybody looks like you and me. Okay. From the mountains of Kashmir, if you have let them in and they reach Jammu City bus stand, you are not going to find them. Okay. So that is what is at stake. The country is behind you. In front is the enemy, behind is the country. Okay. So that training for different sort of classes of soldiers, for different, by classes, I mean sort of work functions, arms and divisions of the army, etc. The training is different, but this is common. That what the stakes are, what the hierarchy is, what your role is. Yeah. And if you have that, then you know what is at stake, right? Now you may say, no, that is the army. We are lawyers. What do we care? No. The burden of upholding the rule of law is on you. Even if you're a transactional lawyer, the burden of upholding your client's interests, safeguarding it, meeting timelines, some burden of keeping economic activity on the rails is on you. Yeah. There are going to be long hours. There are going to be expectations that are not digestible by everybody. So be prepared for it, right? So this is the first aspect. Training and orientation is extremely important, and somewhere I think we are all missing it. Because unfortunate, but I don't know if law schools have this perspective of what the profession demands and whether they're able to imbibe that in some manner or the other. That said, there is the other side of the coin, right? What is the firm doing? What am I doing as somebody who's older, somebody who's seen this before, to tell them that, look, this is a phase. Yes, this phase can be long. Yes, you may go 6 weeks without sleep. Yes, some of it at your age may seem artificially imposed. Some of it is a little repetitive, but there is a light at the end of the tunnel. And there are generations of lawyers who have got by. If I am not the gentlest and the kindest person at work, it is not personal. Please let me know what I can do better and what I can do outside of work and what we can do together outside of work to make this work. Three, how I see it and how you see it will always be different. Can we keep having the conversation so that our sort of experiences and expectations are heard and are not always misaligned? Some firms do it better than the others. Some firms don't do it at all. Some offices do it better than the others. Some offices don't do it at all. I don't know what toxic means. It's genuinely, I don't know what toxic means. As leaders, again, taking the army example, people use the expression, use a natural born leader, etc. See, there are elements of leadership that you can be born with, a certain amount of fearlessness, a certain charisma, etc., etc. But this human element of leadership has to be taught. And there are generations of leaders today that have had to learn leadership on the job. Like, we are saying that the youngsters are not trained to meet the demands of the profession. Leaders have also never been trained on the demands of leadership. They have been trained by the profession itself and the demands of the profession. So today, a top-notch lawyer that has a 360-degree experience, some of the best names in the Supreme Court, can dictate a plaint, can dictate the application, the supporting affidavit. They know what the entire package looks like. They can give it to a clerk to stitch it, go next day, argue it, get the injunction, write a letter to the defendant in compliance with 39(3) and say that, listen, you have an injunction, don't violate it, etc., etc. But they're acting out of memory. And in that, they are training the next rung that this has to be done, it has to be important. Where is the soft skills training coming from? Who has told them that, look, after 3 weeks, 4 weeks at work, you need to break the tempo a little bit, allow them to take time off, listen to them, understand what their families think of the work, understand what's going on in their lives, go out for a meal, etc. Just to sort of bring everybody at a common platform for conversations, right? Mm-hmm. We've not had that training. We've learned it by the hard way. So, and we're still learning it, right? And so therefore, in that process of learning, have we made mistakes? We've made mistakes. Have we not been able to sort of see that the generations have different expectations? There are generational changes. And what worked for someone in the 90s or the 2000s will not work for somebody in the 2020s, right? Needs to be done. Needs to be done. What I'm saying is that while I don't understand the label toxic, I can understand all the compulsions that create the frustration. See, however difficult a work environment is, if you are having conversations, then it's kind of mitigated, right? So that's the second aspect. The first aspect is the training, orientation, and expectation setting for young lawyers. The second is the training for leaders, both of which I think are missing. The third aspect is, it goes back to the first one a little bit, which is that, once you've understood what the profession demands, like you said, you are here voluntarily. See, when it comes to work, and let's say a client's liberty is at stake, a race against time to finish a multi-billion-dollar transaction is at stake, or to do a multi-billion-dollar listing is at stake. You have to have the humility to say that I sort of fade into insignificance. My comfort, my ego fades into insignificance. If you do not have the ability to put service first, then you're in the wrong industry. Right? So all of this needs to be stitched together. Who needs to sort of blink first? We can't be sort of formulaic or egotistic about it. But this needs to be understood. Right? See, there's no one size fits all approach. There are lawyers, seniors of mine, who give complete carte blanche to their younger colleagues, right? Oh, all right, so this important application listed tomorrow, go argue it. Now, their mindset is, what's the worst he can do? The application will get dismissed. I'll take it up at the High Court. Right? Now, you may think that, wow, he's allowed me to just prepare and express myself, etc., etc. But absent the push, because he's going to push himself in the High Court, he's going to, pull out every judgment that supports him after he's lost. He's going to pin, prick holes in the order. He's going to argue his case, and he's going to pull out all his experience and repair it in the High Court. But he was not there to push you while you were at the trial court. And sure, you will learn by stumbling, trial and error, etc., etc. But sometimes that learning could have been accelerated had you both sat down, prepared for the trial court matter together, and spent those sleepless nights pulling out those judgments, understanding what more could have been done over here, etc., etc. So different things work for different people, right? There will be seniors who will say, All right. Before you go to the trial court, where is this? Show me this. Have you done this? Have you done this? Have you not done this? Where is this judgment? Why have you taken this judgment? Have you informed the client? Is the client coming? The client needs to see how difficult a court this is. What if the judge asks you that? Are you prepared for the other side arguing this, etc., etc.? And you may say, why is he saying this? I've done 40 of these matters. But in this senior's mind, in now senior B's mind, he wants you to win, and he does not want you to he does not want to take it to the high court. He wants you to throw the kitchen sink, everything, including the kitchen sink, at the trial court. It's a different approach. Then let's say in both scenarios, you lose. Okay. Now, senior A is going to take it to the high court and, try and have the order reversed. Now, within senior A, there are two divisions. There is senior A1 and senior A2. Senior A1 will post facto conduct a postmortem. Array, I trusted you to do this because you've done 20 of this, but you've not done this, but you've not done this. Anyway, leave it. What can I expect? I will do this. Okay. Senior B will say, Acha, no problem. You did your best. I've got this. Okay. Sorry, senior A2, not senior B. I've got this. Now, you may feel that, this senior A2 is the best, because he didn't put any pressure on me while I was going into trial court, and he's not put any pressure on me after I've lost, and he's going to handle high court himself. Okay. Now, two factors come in over here. One, where is your learning? Okay. Where is the pressure on you for you to learn? Two, now the client is going to pay for an outcome. Okay. What are the chances that the client is going to pay for multiple rounds of your trial and error, and then for the senior to fix it himself? So what you're setting yourself up for is, on multiple matters, you will have your work written off because the client is not going to support an earn while you learn program. That's the reality. Look, that's the reality. Okay. What does that do to your financial progression? You are relaxed. Your senior has not put any pressure on you. What does that do to your financial progression? That for matter after matter, let's even take in a case that you win, but that order gets set aside by the appellate court, by let's say the high court. Okay. What is the chance that the client will come back and say, I know he won, but, I need a discount because the high court set it aside. So therefore, there was the preparation for the victory itself was not 100%. There were gaps in the preparation. Now the client is, a factor. Okay. Now you come to senior B, pushed you, you lost, irritated you, put pressure on you, but that body of research, that preparation carries on for the high court, right? I mean, you don't have to repeat it. Okay. So one way or the other, you're going to get paid because you don't have to repeat it. That senior B cannot also now yell at you because the preparation was under his nose or her nose or whatever, and whatever that X factor of either sending you to court or the senior going himself was a conscious decision. Okay. But the sort of life became hell for those 2 weeks that you prepared for the application. But that is now, that preparation is repeatable, scalable. A, it will come to use at the appellate stage, so you don't have to reinvent the wheel. B, it will come to use in your successive applications, and you'll understand what went wrong. In either of these cases, the onus on, so I'm just sort of giving some contrasts and, where you think a young lawyer may be more comfortable. But in either of these cases, I'm not saying one is right, one is wrong. I'm just sort of giving examples from my experience. In either of these two cases, the onus on you is to learn. The onus of learning is on you. All right. If you choose not to learn and make the same mistake again and again, I'm telling you, you come to me and say, you raised your voice because I made the same mistake again. See, a mistake once is fine. The same mistake again is coming at a cost for someone. It's not about the hourly fee or the monthly retainer, or that mistake again is costing somebody their liberty, is costing somebody, a vote on their equity shares in a company, is costing somebody control over an estate. That human emotion, yes, we have to be a level removed, or more than one level removed from our client. But if you do not empathize with your client as to what he's going through, okay, and do not have the ability to react to it, again, you don't belong in the profession. Right? Understand who we are here for. Understand who we are here for. I think that's it goes back to the training bit, but it's also understanding what the larger game is over here, right? Learning from your first mistake so that you do not make the mistake again. Of course, in a litigation environment, there is a very large element of luck of the draw, right? You may draw a tough bench, you may draw an easy bench. A tough bench may be having a good day, an easy bench may be having a bad day. All understood. But by and large, this is a law of averages. I'm not going to pinpoint one client, one matter. By and large, hard work, dedication, understanding the dispute resolution environment pays off. Your maturity pays off. When are you going to get there? Now, if I'm sort of pulling you up, Sarthak, for your inability to get there, and you think, yeah, this guy is toxic, of course, we need to talk. Of course, you need to tell me to my face that, look, this is not possible. And I need to explain to you why it has been possible in the past. And you know what, let's do this over a cup of coffee, or, different colors of liquids if you prefer. But that label is easy to throw around. That label sticks easily. And frankly, I don't even know what it means. So just think of these things when you describe an environment. In a firm, I'll tell you, the last factor that comes in is, in a firm, sometimes because the teams are larger, this translation of expectations, this communication is very often by Chinese whispers. Senior client says something, senior partner says something, partner says something, senior associate says something. Now there are principal associates, partners designate, principal associate designate. By the time it gets to some 23-year-old as to what the expectation is, it is make a list of dates, or whatever, make a list of documents in the data room. So these Chinese whispers, of course, sometimes leads to a mismatch of expectations, and that is entirely avoidable if everybody spends 15 minutes more and either explains or asks, right? Which is entirely possible, right? And I'm telling you, even if it is at the cost of, I'm not saying me or somebody else who does it, somebody comes and asks, I'm not entirely clear what the purpose of the list of dates is. Okay. Let's say in a given scenario, I react and say, "Arey boss, I saw your CV that had about 6 litigation internships and you do not know what a list of dates is. Incredible. I don't know what people are doing." Let's say I start off with this, right? Disheartening. But then I say, all right, I can't afford them not to know what a list of dates is or what the purpose is. Do this, go to that folder, pull out this list of dates. I will show you what a list of dates look like, what the requirements are, how it is to be set up, structured. And they do it. That half an hour is invaluable. It starts off with an expression of irritation, but by the time you're done with it, you respect the individual for having spoken out freely. admitted to not knowing something and having learned. Now, how many juniors are doing this? I don't know. Hand on heart, I don't know. I'm not going to make a guess that 5% are doing it or 75% are doing it. I don't know. How many juniors are then saying that this, lawyer has now spent an hour with me teaching me how to make a list of dates, and this is now ingrained in my system. It is not going to go out. This is now translatable, scalable, repeatable, and I'm going to become more efficient at this. And I'm going to be able to, when the next batch comes in or two batches later, I'm going to be able to train my younger lawyers to do this because I had the opportunity of learning list of dates from Zia Modi herself, which everybody doesn't have. So who has taken that session, that 1 hour session with Zia Modi, KG Raghavan, Uday Holla, Mukul Rohgi, whatever it is, and said, boss, this is an irreplaceable 1 hour session. It is my duty to teach future generations how to make a list of dates. You tell me how many people are doing it. So, sure, the only thing that people remember from that conversation is, yeah, come on, I saw 6 litigation interns on your internships on your CV. You don't know what a list of dates is. Chalo, anyway, what choice do I have? That opening may be wrong, but also kind of natural. Because, well, you said you said I used to actually run the practice. The senior was too busy, doing the Supreme Court work. Trial court, so I used to run the practice because his juniors were always shadowing him. So the rest of the work was left to me. And that is the impression that I get from your CV. So that irritation has come out. But if that is your take home from that conversation, then again, we're all missing something here. So again, long-winded answer, Sarthak, and I don't know whether this is going to be a popular answer, but it is what it is.
Long-winded, but again, extremely insightful answer. And I'm glad you're taking the time to answer these questions in so much detail. Now, sir, after having spent 2 decades at the law firm, at what point did you decide to finally branch out on your own and set up independent counsel practice?
I don't know. I don't know if there was like a moment in time, but I think increasingly the feeling was that I could do more things, different things. I could have different roles within the ecosystem. I could have self-expression. So it's a lot of these little things, right? So I want to do government work. I want to do work for individual clients. I want the sofa in the reception to be red and not green. I want to work on Sundays, but I will not come back to office after 1 p.m. on Friday until 1 p.m. on Sunday. You can have 100 things running in your mind that that I want to do this differently. That I want to Friday afternoon in school and college. I used to go for a movie every Friday. When I say school, I mean my 11th standard, not 12th, because 10th and 12th were boards. And then again in college, every Friday I used to go for a movie.
Wow.
So I must confess that I've not sort of gone back to it again, but the ability to do that, once you finished court on a Friday, and you know that you next have court on Monday, and then you're willing to work on a Sunday. So go watch a movie on a Friday afternoon, go back, spend time with your family, be at the farm on Saturday until Sunday morning, come back. It's just something that you want to do. It works for you. You want to take matters that are that affect individuals more. You want to take matters that affect, I mean, that the government is briefing you on. You want to take matters that are non-corporate in nature, uh, so on and so forth. You want to have your own uh, flair for advocacy, so on and so forth. Uh, you need a platform that is not a collective platform. You need a platform that you own.
Yeah.
For most part, I have to say that the firm allowed me self-expression, but then there are institutional constraints, right? To answer your question, I don't know whether there was a exact point in time that in 22nd of May 2023 I decided this is only going to be 9 more months or 10 more months and I'm going to leave. But all of these thoughts were, including the point about the sofa in the reception, right? I want my office lobby to have a red sofa. You know, see, if you and I are in partnership in a law firm, and I think the sofa should be red, and you think the sofa should be green, we're not going to fight about it. We're going to get some compromise color, or we're going to, tell some admin staff to go get a sofa or something like that, or leave it to some. And both of us are going to be unhappy about the color of the sofa. I mean, we may be rocking in the practice, but we'll be unhappy about the color of the sofa for the rest of our life, right?
Yeah.
So, so yeah, I wanted the lobby sofa to be red, and today I can.
Now, so when one is, Aditya, when one is working at a law firm, no matter which rung one reaches, one's identity is always going to be behind the firm. At least
Yeah,
that's my impression of it.
yeah,
And when one branches out on their own to set up counsel practice, you're again on a journey of establishing your own identity,
sure.
which could be something as small as red color sofa and
Yes,
something as big as setting the culture of the chamber. So
yes.
I'm just wondering, sir, Aditya, in this backdrop, how has the transition been from being a senior partner to now a independent counsel, and how are you thinking about establishing yourself, your own identity in this profession, your own niche, and so on?
Yeah. So, uh, it's been a little over 6 months, and uh, that's a fairly long time. At the same time, it's in the context of how long our careers are. And I'll tell you this favorite story of mine about the length of our careers in a little while. But in the context of how long our careers are, 6 months is still sort of baby steps.
Hmm.
Uh, but yeah, the aspiration is to create my own brand, my own identity, do things that I was doing at the firm, but with a different flair, with a different approach, to be able to take views that are not necessarily a consensus view, to be able to take a view that is informed by what is likely to happen when I take this to uh, the court in which I practice in, and not necessarily be burdened by the ups and downs of 600 people over a period of 20 years, right? See, I'll tell you what happens. So, for example, if you took a particular position as Sarthak before the Delhi High Court in 2023, okay, and suffered an order, your view was not accepted by the court, and division bench and Supreme Court just said, on an overall basis, we are not inclined to interfere over here, right? And you and I are partners in a firm that has 600 lawyers. Your experiment, which probably didn't work, or your view, which probably didn't work before that judge of the Delhi High Court, and then on a sort of overall basis, division bench and Supreme Court said not inclined to interfere. Chalo, go to trial, or there are larger fish to fry over here. Move on. Court time is precious. That position becomes entrenched in the institutional memory of the firm.
Oh.
So when because why? I mean, into the firm, you didn't go as an individual, you went as a partner of a firm. You have circulated the judgment within the firm. It is now part of my institutional memory. Okay. I cannot now say, Acha, that was Delhi, Karnataka ka mile. Let's try. Right. In individual practice, that single judge's order is it's a precedent. There could be, it can be tested. We'll test it. Right. So the trick is knowing that that precedent exists, knowing that some of the law is against you, and to be able to argue against it without having to be burdened by the institutional memory of the firm. And that is, that is the freedom, the creative freedom that individual practice gives you. You are negligent if you don't know the precedent. Let me be very clear. If you ignore the precedent or do not know of it, you are negligent. But knowing it, after having informed the client, if you're willing to take it on without being burdened by it and saying that, listen, there is an opportunity here. This was not argued by Sarthak as I remember. The facts were slightly different because ABCD as I remember. Right. And it's not just courts. You may have had a conversation with the Reserve Bank of India. Right. Reserve Bank of India says no, whatever. Okay. Regulate. Okay. And then that becomes part of the institutional memory. That Sarthak went to, executive director or deputy governor, Reserve Bank of India, and he said, nah. Right. Then can I advise the client, no, listen, you know what? Let's test this before the High Court. I may, but it'll have to be, but the Reserve Bank of India is a respected regulator in the court environment, and they're going to say, nah, and then, we're going to. So that sort of weighted advice, that advice is not, let's give this a shot. Okay. So part of the journey is that to be sort of unburdened by memories of. So if the current sort of strength is 600 lawyers, and if you take every lawyer that has sort of walked through the firm over a period of 22 years, to be unburdened by the collective memory of all those people. Yeah. So that is part of the endeavor. And I'm hoping that, that will add a flourish of freedom to the expression that we bring to court. So that's one. The second is a lower a more nimble footprint, a smaller footprint that is in the right cases collaborative with everybody, right? So look, I have a matter in Delhi. I genuinely think that the best resource on this kind of matter is sitting in a law firm. Mr. Client, go and engage that partner in the law firm. You work out costing with him. I'm willing to work with them. I genuinely think that the best lawyer for this matter in Delhi is actually Sarthak. Bring him on board, right? I genuinely think that I'll be able to do a great job of this matter actually before the Calcutta High Court. Don't need to engage anybody, right? These conversations, again, if you're sitting in a large law firm that considers another large law firm a competitor, you're not going to send a client to say that, listen, bring another partner because I genuinely think that he is the best resource. Or you are not going to, so you have a Delhi office. In that Delhi office, there are 30 or 40 associates in the litigation team. You're not going to say, you know what, leave everybody aside. I want a young lawyer called Sarthak to come on this matter because I've worked with him and I like him. You cannot. Why are you creating a layer? You have a Calcutta office, let us say, you are not going to fly from Delhi to Calcutta to go and appear at the High Court because then, Calcutta office kya karega? And that is there territorially. They feel that, they know better, etc., etc. So this nimbleness, able to assert yourself when the sort of gut is right and able to collaborate without being competitive when the gut is right. So this is the second aspect of this expression. The third is, again, so just to tell you, like statistically, I used to be in court, let's say, for 4 or 5 matters a week when I was a a litigation partner at the firm. Uh, I am in court for 10 matters a day when I'm an individual practitioner. So some of those hearings are effective, some of them are non-effective, some of them I win, some of them I don't win. But the learning is, 20x. Each interaction with the judge is learning for me. Each interaction with opposing counsel is learning for me. Each time I read the papers, it's so while uh, each of my matters is not uh, as complex or as heavy as the matters that I was doing in the firm. And some of those matters, of course, the firm is kind enough to continue to brief me. But just this repetition, this volume is teaching me, right? And from that, I learn. And from that, I go back to the first point, which is my ability to give advice that is tailored from my experience and is unburdened by somebody else's experience. Yeah. Uh, the culture then, again, how many younger lawyers are you willing to take? What is their growth path? If they do well, what is going to happen to them? If they, let's say, have aspirations of independence, how are you going to promote them? If over a period of time, if you understand that there are mismatches, what are you going to do to them? That's going to be a learning for me. I want to be able to continue the seriousness with which I see matters, but since I'm now not stressed about uh, others' relationships. So you understand, it's like this. You have, say you and I are partners, right? And you come to me and tell me that, look, this client has an urgent filing in Bangalore tomorrow. And I need you to be on it 24/7 until, the relief works out, etc., etc. Of course, I have professional pride, and I have, once I take a matter, I will do it to the best of my ability and give it everything. But the added stress of, look, this is very important for Sarthak, and Sarthak is very important for me. And I'm going to have to see Sarthak every day for the next foreseeable future. I cannot disappoint him in any way whatsoever, right? Is an added stress. Yeah. So the expectation is that I'm now one level removed from my former partner Sarthak, and therefore, while I respect his relationship with the client, the stress does not weigh on me as much, and hopefully, I do not then pass on that degree of stress to the younger lawyers working with me, right, into the system. So that culture, take pride in your work, but don't let everything stress you out.
Yeah.
Yeah. How do you celebrate your festivals? When do you close office? When do you not close office? What are your office timings? What does your office look like? What does your stationery look like? How do your bags or how do your files go to court? Is it? I know a lot of lawyers like those jet black bags with gold lettering. I mean,
Yes.
I think that's done now. Like it's ho gaya uska, there's so a lot of these things go into how you're going to come out on the uh, other side. Are you going to be a career uh, trial lawyer? In somewhere down the line, is somebody going to say that look, Aditya, you've done this long enough. We're going to give you another type of gown? Or is somebody going to say, you spent enough time on that side of the bar, do you want to spend some time this side of the bench? All open questions. No, I'm in a never say never environment. So uh, everything is the first time. Everything is open. So let's see. Like I said, in the context of the length of a profession, 6 months is still baby steps. I'm I've understood some things well, and I'm sort of still working on others. Uh, yeah, let's see how it comes out.
Now, so moving on, the question of hiring associates.
Huh.
As a senior partner, when you were hiring associates, even though they were working in your team, they were still associates of the firm. Now you're hiring associates for your chambers. So
Right.
when you're hiring, what are the skill sets that you're looking at? How is it different from hiring associates for a firm when you're hiring an associate for your chamber? And because most of our viewership is of law students, how do you think people can become better equipped in order to work either in a firm or in a law chamber? How can they figure out हमारे लिए क्या better है?
Yeah. So one is you have to do a little bit of experimentation and discovery yourself, right?
Mm.
There is no one size fits all approach. There is a one size fits one approach, right? I have to find the right office with the right senior, with the right kind of work that that works for me, right? Uh, the last week or so, there has been. You're aware that some of these enrollments, etc., were the 2024 enrollments were delayed because of the Supreme Court's judgment on what fees the State Bar Council can
Yes.
collect or not collect, etc., etc. But the office of the Bar Council in the Karnataka State Bar Council in Bangalore is right next to the High Court and is actually between the High Court and the Commercial Court building. And so therefore, every time I walk from the High Court to the Commercial Court building for the last week, 10 days, I've been seeing young lawyers or young law graduates about to become lawyers in large numbers, like hundreds and thousands, coming there to enroll and take their certificates, etc., etc. One of my younger colleagues was in that process as well. She graduated this year and enrolled about a week back. So the uh, I heard somebody talking while I was passing them saying that, it is better to join a small office and learn rather than to join a big office and be lost in the bigness or the sort of vastness of that office. And that's not necessarily wrong advice, or, that's not necessarily the wrong presumption. What I said to them as I was sort of walking past them is, it's not about big office or small office. Join an office that will give you a lot of work,
Mm.
right? Uh, and different kinds of work. So for that, that office has to have a lot of work, right? To share work with you, that office has to have the work to share. So join an office that has a lot of work. Two, don't be don't think that the profession is a straight line graph of some sort, where if you join as an A0, join a law firm as an A0, you will only come out as a senior partner in the straight line of progression, etc., etc. If you do well, that you will reach the pinnacle of equity ownership within that firm, and that is how you're going to uh, be sort of that's how you're going to exit the profession. It's not necessary. A lawyer can be in practice for 40, 50 years. Uh, if you think that, look, something is working for you at a law firm and you're able to extract that learning by spending 3, 4, 5 years, yeah, there is an element of, if you get addicted to the paycheck, yeah, it kind of restricts your ability to do something else. But that's an element that you have to overcome, or you have to plan for it, that let's say 3, 4 years later, I don't have a regular paycheck, or I have a regular paycheck, but if it's of a different size, so on and so forth. If you plan for it, then you can find something else that works for you. Don't do this thing of 6 months. Oh, it's not working, toxic environment, or the AC is too cold, or the hours are too long, or the rent is too high. It's all nonsense. I apologize for the bluntness, but it's all nonsense. Give it 4 years. Okay. You will find that the AC actually works fine. Just put on a sweater. Okay. You will find that at some point in time, you'll find a nice apartment where the rent works for you. Find all that. You'll find that the hours are not that. Right? Give it 4 years. And then you take that learning, and if you think that, look, this is the place for me, and yes, my destiny indeed is to join the equity cap table at this firm, then please continue. But if you evaluate after 4 years and say that, listen, I could be doing a few more things, and here are the opportunities again, and they will be learning all over again, and there will be some stumbling and falling, and I have to keep this baggage of now I was almost a senior associate, or actually a senior associate. If you keep that aside, you'll do okay. So the first, so this all goes into the first piece, which is there is no one size fits all approach. Find what works for you, give it 3-4 years, and then sort of see what else you want to do. In finding what works for you, have 100 conversations. Don't be shy of having conversations. Don't buckle to peer pressure that, oh, so and so has got a job at 1,14,000 rupees a month, or like it is now advertised at 20 lakhs an annum, or whatever else it is. Don't buckle to that. It works for them. It works for someone else. It could work for you, but is that what you want to start off with? Be intelligent. Does working in your hometown actually work for you? Maybe it does, maybe it doesn't. Is there a senior in your hometown who, if given the right support, could scale their practice and send you to the Supreme Court every couple of weeks? And then you have the best of both worlds. You are in your hometown, and you are supporting a senior who now has the wherewithal to send you to the Supreme Court every couple of weeks. So you're making a name for yourself in the Supreme Court. Where is this thought process? That, the best lawyer in, I don't know, Guwahati, Jabalpur, Lucknow, Prayagraj, whatever, may have an opportunity for me while I do not, or whatever, Amravati for that matter, or in Karnataka, Dharwad or Kalburgi. I'm not going to lose the opportunity of growth, even if I work and enjoy home food for a few more years. Keep thinking. So this is on your thought process side. On what we are looking for as solo practitioners, or as somebody who was earlier in a firm, it's 3 or 4 things. One is, have you made that switch? Have you switched off the valve in your mind that keeps telling you you're a law student? And have you switched on the valve that says that you are now a lawyer? Okay. Because once you switched on the lawyer valve, you are now responsible for outcomes in court. Some of those outcomes can be permanent. Are you willing to take that responsibility? That's the first thing that we're looking for. Okay. A related aspect is, what is your relationship with the office that you are joining, right? Yes, there has to be a brotherhood. Like I said, we are equal, so therefore there is a brotherhood, sisterhood, mutual respect, brotherhood. Yes, there is an element of those of us who've done this for a little longer, mentoring individuals. Yes, there is an element of those of us who've created the platform, created the chamber, providing comfort and the infrastructure, making sure that you're comfortable, facilities work well. The office has a good library, the office has support staff, printer, computer, internet, pantry, tea, coffee, snacks, etc., maybe a cab service, whatever else it is. That onus is on someone like me. It's not on you. Yes, could grow to be friends, but eventually understand this, that you are an independent professional who is responsible for their work product. If today you set up shop and said that, look, I don't want this massive law firm, I don't even want this guy's chamber, I'm going to set up my own shop. The statute allows you to do it, right? And that's why I say that your degree and my degree, your enrollment and my enrollment, your certificate of practice and my certificate of practice are the same, because the statute allows both of us to set up shop wherever we want, including in a residential area. We don't have to go to a commercial area. That's the beauty of the profession. So why is that? And if you are then setting up shop on your own, right, you are responsible for work that comes in. A client comes and gives you work, and that you are answerable to the client, right? The switch I want you to make is that you are more than welcome to use my chambers. You do not have to go out and look for work for the most part. The profession and God have been kind to me, and I have work to share. So you will get it, right? I will create the infrastructure. I will create the environment. I will give you opportunities, or rather help you discover opportunities. There will be food, water, air, light, all of that, right? You can learn from my mistakes. That's an additional advantage. You don't have to make the same mistakes yourself. But treat me as your primary client. I am the source of your work, and in that sense, amongst all the other relationships that we have, brother, sister, mentor, payer of electricity bill, etc., amongst all the relationships that we have, I am also your primary client. I am the source of your work, right? What you do right benefits me. What you do wrong debilitates me or puts me in difficulty, right? And in that sense, I expect accountability for your work. Of course, I know that there will be mistakes. I wouldn't hire a first-year lawyer or a second-year lawyer or a third-year lawyer if I didn't know that there will be mistakes. But that mistake has to be exactly that. It cannot be negligence. You understand? Because when you are in your solo practice, the headroom available to you to make negligent errors is zero. That client will never come back. You have no band-aid to put on it. And the client will, by word of mouth, not send you any more references. Right? Take this and put it and apply it to the firm that you're working for or the chamber that you're working for. Why are you not doing it? My work has real life consequences. The firm is my primary client. I raise an invoice for professional services on my firm. I am therefore accountable for my work. You do this and 90% of your complaints will go away. If you smell the coffee, 90% of your complaints go away. Because you are accountable. So that's the expectation. See, we can good knowledge of English, articulation, tenacity, should be well read. I like people who do other things in their life, are not sort of confined to just the law, but have music, sport, especially team sports. I like those people. But the bottom line is, I like people who understand that this is, in fact, an attorney-client relationship. And your primary client just happens to be another attorney, right? You lose out on this, the profession is kind of difficult because you will never get why the other guy is so worked up. So that's what I'm looking for. That's what I was always looking for. That maturity to turn on that switch. Yeah. You should take with pride the fact that, look, my primary client is a lawyer. A lawyer needs help and is coming to me. And therefore, I used this expression earlier in the conversation also. I am a lawyer's lawyer, and that has to keep me pumped up 24/7. People who do this will do well.
Wow.
It's not going to be, again, it's not going to be popular because there is, in an urban environment, there is a sense of comfort and entitlement. I'm not going to say about generations, Gen X is like this, Gen Y is like that, Gen Z is like that, millennials are something else. No, no. In an urban environment, there is an element of comfort and expectation and entitlement. Get rid of it. Whatever stage of life you are at, nobody is here to give you anything on it.
Yeah. Now, sir, since I've already taken much of your time, I'll quickly come to the final question that I'd
I know
like
it's
to.
been a while, right?
It's been a while, although it didn't feel like it at all. And I have
I'm
so
sorry. I'm sure you have sort of better things to do on a Sunday than speak to
Not
me.
at all. I'm sure you have better things to do than answer my silly questions, but I'm not letting you go just yet because I'm learning a lot and I'm sure our viewers will also find great value in it. Now, so this is the final question, and I put this question to almost all the guests who are on the show. Imagine if there's a magic wand that's waved, which
Right.
sends you back to the year 2003, the
Right.
year when you started practice. And right now, with this magic wand's magic, you have all the knowledge and experience that you possess now, but you don't have the resources, the money, the connections that you have at the moment. So, how do you now go back and build your practice from the ground up? What are the things you would do differently? What are the things you'd repeat? And are there any mistakes that you would avoid and things like that?
Yeah. So, one thing that I often tell younger lawyers that work with me, or sometimes even to my peers, that and this was true when I was in the firm, uh, more true when I was in the firm than over the last 6 months, is I genuinely believe that I was a better uh, more knowledgeable lawyer in 2003 because I used to read. I used to read, the SEC journal cover to cover.
Wow.
I used to read fiction. I used to finish a book a week, on an average. So read. If somebody said, is this permissible? I would say, yes, yes. Supreme Court has said this recently, only about 3, 4 weeks ago. It's in volume 6 or volume 7. Go look for it. Uh, so uh, when you say that I'm going to have the knowledge that I have now, I hope that I will also have that which I originally had in 2003, because I used to actually be reading all the time at that point in time, both fiction as well as the reporter, the journal. So that's point number one. Point number two is what I've already mentioned, that the softer sides of engagement with fellow professionals, fellow colleagues, younger lawyers, uh, clients, etc., came to me over a period of time. Some of it I learned from my mentor, some of it I learned by trial and error. And I think that if I'm able to deploy those, the interpersonal relationships, I'm able to deploy those, it's going to be invaluable. Uh, the third is that given that I already know, where my values that my parents, my faith, my seniors gave me, that there is not just one light at the end of the tunnel. There are going to be multiple openings to the tunnel with a lot of light flooding in from all over. There's just going to be so much more reassurance that hold on to your values, hold on to, the principles. There is no need ever to compromise on them. I think it's going to be a far more comfortable journey. Uh, the fourth is, uh, Sarthak, the point is that the magic wand is already there. It was already there. You're in a knowledge-based profession that very few individuals are fortunate enough to be in. You've been, your parents have sent you through a system of education. It's not just a knowledge-based profession. It's a powerful, empowering profession that allows you to both take on the system and mend the system, right? So that magic wand is inbuilt. You don't actually have to wave it at the end of 21 years.
Wow.
So that magic wand is always there. So use that. Finally, the things that you mentioned, the connections, the experience, etc., etc., all of those are important, but there is an element of grace that your parents' uh, blessings from the Almighty give you, and there are elements that are written on your forehead that no amount of magic wand waving is either going to erase or rewrite, right?
Yeah.
So accept those blessings and develop them. Your number one source of good fortune and blessings come uh, from your elders and your parents. Don't take those for granted. Accept that grace and develop that. That's in the context of somebody waving a magic wand. Your parents have already waved a magic wand for you.
Yeah.
That's my take on this. But I think overall, I think it's going to be a far smoother journey, because that stress of, is this hard work ever going to pay off, is not going to be there. It's going to pay off multifold. The profession is going to give you things that you didn't even imagine are out there.
Wow.
Right? You're going to get, I mean, it's going to be, it's there are going to be treasures that the profession is going to give you that you didn't even know existed. And that, knowing that, if somebody can assure a young lawyer that that is going to happen, I think that's the most liberating feeling. There is the condition, of course, is honesty and hard work. So you don't get caught up in, oh, he's making 20 lakhs an annum, and he gets a cab to go to office, and he doesn't have to run around physically in the magistrate's court, doesn't have to carry the files, and his office has given him a laptop. I don't even have an iPad. Forget it. It's all iPad, iPhone, Rolex, etc. Everything's going to come. It's going to come 100 times.
Yeah.
The profession is going to give you treasures. I'm not using the word riches. I'm using the word treasures that you never even imagined. Just persist. Just keep your faith intact. Keep your hard work intact. Accept the grace that the Almighty has given you through your parents.
Wow. So even though this would be the perfect note to end this conversation, and I did say that the last question was indeed my last
I
question, but
know.
I would be remiss if I don't ask this final question, and this is final in earnest. So throughout this conversation, I've had the benefit of experiencing that you speak so slowly, you think deeply, you have profound insights on almost everything. And I'm curious to know, how did this happen? Have you always been a deep thinker? Is it a result of a progressive reading over the years? Because this skill is, I wonder if it's skill or if it's something else. Uh, what is all this about? Because I feel like this lack of anxiety, this ability to speak slowly, this ability to not rush anywhere and just be in the moment. How does one build that if one is so inclined?
Hey, when you say, have you always had it? Uh, my mother tells me that, when I was 2 or 3, and uh, if she would say something that this is to be done, this is not to be done, my answer would always be, why? Kyun? Why is it like this? So, yeah, so there was an element of uh, curiosity and learning, I guess, from that point in time. Reading plays a very important role. Travel plays a very important role. And eventually, this is going to sound repetitive. Some of whoever you are, it is, if somebody else thinks that you've done well for yourself, it's a grace that you've received, right? You have made it easier on yourself by having worked hard and worked honestly for it. But there are others, like your parents, who've contributed to who you are, and never ever forget that, and receive that grace with a lot of acceptance and humility yourself.
On
So it's a package. I can't put my reading is extremely important. Travel, I think, is not being narrow in your reading and not being narrow in your travel. I think these are these are these are elements that would stand out for me. But
So since you've mentioned
most of it is
reading,
received.
that's
Go ahead.
wonderful. So since you've mentioned reading quite a bit, and lawyers often feel reading fiction is a waste of time. One should either read non-fiction or read, like you said, law reports. Would you like to give some good fiction recommendations to our viewers, including me? I'd love to get a read on the books you
Not,
think are
not
interesting.
at all. See, if I turn to my left over here, I have a part of my library over here, and that has I can look at my R.L. Stevenson, Robert Louis Stevenson collection over here. I can look at my Asimov collection over here. I can look at my Umberto Eco collection over here.
Oh, nice.
I can see there is a book by Stephen King, who's a horror writer, as you
Hmm.
know. But this particular book that's right next to my table is on drafting, on how to write.
Wow.
See you. There is my part of my Indian history collection is over here. There's a particular fictionalized work on one of the kings from Karnataka. It's a
Okay.
mixed bag. It's a mixed bag. I can see
Wow.
a part of my George Orwell collection over here.
Wow.
I can, in fact, my Enid Blyton collection is also right here. So read
Wow.
everything. Uh, don't let anybody else sort of tell you that, oh, Amish Tripathi is not good, read so and so, or Chetan Bhagat is not good, read Chetan Bhagat.
Yeah.
Okay. There is a chance that because you've gotten into the habit of reading, once you've exhausted Chetan Bhagat and you pick up some other book, you will see that, there is a superior craft,
Yeah.
which now appeals to you because Chetan Bhagat opened the doors for you, right? Uh, don't you don't have to be snobbish about anything. I can't recommend an author. Uh, I
Hmm.
can't just uh,
Absolutely.
walk into a bookshop and pick the first thing that sort of that catches your fancy.
Wow. Now, even though I don't want this conversation to end ever, at some point I'd have to let you go.
I
And
know.
so, thank you so much for your time, sir. And I'm so sorry I kept you for so long. But this conversation has been so enriching for me. It's like a lifetime of learning condensed into a few hours. Thank you so much for your time, sir.
Very kind, Sarthak. Very kind of you to have had me. I enjoyed speaking to you, and let's stay in touch whenever the opportunity sort of presents itself.
Absolutely. Thank you, sir.